Dr. Boala.
Good morning. Thank you for having me.
So let's first of all start with, of course, you saw some of the lead stories, the NJC, some of them would be brought in from next week, 11 of them. So there are new change of guards coming. But I hear that the ones, some of them have not really done justice to the law with some of the outcomes from the court, especially with the Plateau State and what we saw as the outing there. What are your takes on Plateau State to start with?
Well, thank you for having me. While the take from Plateau is a bit unique and different from other decisions of the Court of Appeal in Nigeria, is that at the moment, apart from Kanu, the Plateau is one judgment that has irked the minds of a lot of legal professionals, legal minds, public pundits, politicians, and the Nigerian people. And why do I say that? Because if you look at the decisions, first of all, decisions from trial court can be understood even if they are divergent in their opinions and in their judgment, because it is believed that the trial court would have evaluated the evidence, they received evidence. So how the evidence are tendered, how the arguments are canvassed, and how they arrive at their judgment might be different. So you can understand when trial courts have conflicting judgment because it is based on the facts that they evaluated, right? So, but when it comes to the Court of Appeal, it is meant to be a decision by that court that is purely guided by law because they are reviewing the decisions of the trial court. And so it is expected that at the Court of Appeal level, you are supposed to have some degree of unanimity of decisions on principles of law. Facts can differ, but facts might be the same. Facts can be different and facts can be similar. Now, if the facts are the same or similar and they are drawn from certain principles of law, irrespective of their unique characteristic, the law is constant. The principle of law is constant. So, for example, if in Court A, the facts are tendered, the argument that are made in support of those facts are to suggest that there was no Congress in a political party. Then in Court B, the facts that the documents that are tendered, facts that are laid, evidence that was laid, suggests that there was no valid nomination of a candidate from primary. Or in another place, the facts that were, canvassed before the court, the principle of law and the argument made was that somebody was not qualified. Now, whether it is lack of Congress, lack of valid nomination in the primaries, or that the person is disqualified in Congress or primaries, they are similar facts, right? But they are bounded by one principle of law. And what is that principle? That all of these issues border on pre-election. So when Court of Appeal is reviewing the judgment of a trial court, the Court of Appeal is looking at whether or not, irrespective of the distinctive nature of these facts, whether they fall within the purview of the principle of law, whether pre-election matters can be entertained by election tribunal. Now, why Jos is unique is that the one in Benue, the one in Ebonyi, and in some other places in Nigeria, the Court of Appeal held that pre-election matters cannot be canvassed, and if they are, cannot be admitted. The Court of Appeal lacks jurisdiction to determine pre-election matters because pre-election matters are matters that ought to have been discussed in the Federal High Court. And even if they are to go on appeal, when the decision of that Federal High Court goes on appeal, it is going on Court of Appeal not sitting to determine tribunal matters. So, but in the case of Jos, the Court of Appeal entertained pre-election matter. So that is why that now became distinctive. And the reason is because there is already a decision by the Supreme Court that set the pace. That decision of the Supreme Court came first before all other courts in Nigeria. The Presidential Election Tribunal, sitting the appellate court and the Supreme Court, settled the issue of pre-election, that pre-election matters cannot be entertained by election tribunal. That setting of the law by the Supreme Court under our doctrine of stare decisis and judicial precedent has now become the baseline for which all courts below them are supposed to follow. Because Section 287 of the Constitution says the decision of the Supreme Court is bounded on all courts below them and is to be obeyed and enforced throughout the Federation. So why did the Court of Appeal, JOS, in JOS matter, did not follow the principle that was laid by the Supreme Court? That is what makes it unique. And that is what generates this conversation everywhere. And people are confused as to why the Court of Appeal judge will deliver a judgment that is different from their own brother judges in other jurisdiction. Meanwhile, the facts are similar. The border of pre-election. In JOS, the argument, the Court of Appeal said that the trial court disobeyed the court of the decision of the Federal High Court that mandated them to go and conduct Congress. And they on the basis of that, they now disqualify the governor. So the question is, if you look at Section 34 of the Electoral Act, we look at the four grounds. We look whether you will see disobedience to court as the ground for disqualification, because as a tribunal court, your focus is on Section 34, the reliefs that are seeking there. If somebody is challenging the victory of a candidate and the grounds for which is challenged does not fall within this four grounds, the court lacks jurisdiction to entertain it. That is what makes it unique.
All right. Dr. Boala, you made very interesting assertions there. Now, you are saying that pre-election matters should not have been entertained at the appellate court. Are you saying that the court, the tribunal does not have jurisdiction over such matters?
Yes, exactly so. Because the election petition by our Supreme Court, the principle has been laid that it is a sui generis. In other words, it is a different character of sports. So, for example, if you are playing football, in football, when you touch the ball with your hand, it's called handball. In basketball, when it is with the hand you play the ball, they have different characteristics of play. So, in the rules in election tribunal is that Section 34, anybody that will challenge the candidacy, the winner of an election, he must come under these four grounds. Because of time, I will not, mention them. Now, the reason why election tribunal is different is that if the ground you're bringing does not fall within this four, then that means the court does not have the jurisdiction to hear. Now, this election cycle has been broken into two: pre-election and post-election. Pre-election matters are disputes that arose before the declaration of the winner of a candidate. It could have arisen from Congress. It could have arisen in the build-up to the primaries. Once the name of a candidate is submitted to INEC and INEC publish it, that means they kickstart the election matters. So any ground that you're challenging must be whether the person did not win the lawful majority, whether the person is validly nominated, but he does not meet the requirement. All of those grounds, you are supposed to make your argument on that ground. Now, in JOS, they may have made those arguments. But what we're saying is that the trial court in JOS dismissed those arguments that they made. They went to Court of Appeal, and Court of Appeal upheld their argument that they disobeyed, that the governor disobeyed the declaration by the Federal High Court that they should conduct Congress, so that in the first place, there was no even structure to warrant that a political party will sponsor a candidate. Again, it falls under that principles of law that submit that to pre-election. Even if the Court of Appeal were to be a pre-election court, even if let's say, put it this way, that the Court of Appeal is hearing the matter on pre-election, assuming it is not even election tribunal, the argument can be made that the disobedience to the to the Federal High Court decision that they are talking about was in fact obeyed by that court. But the reason why we do not spend much of the time to delve on that is because that argument, whether or not, is to be made in the Federal High Court because it is a pre-election matter. And the law is clear. Once the law sets out the principle upon which the court sits on a matter, if you do not fall within that principle, if you are not obedient to that principle, that court lacks jurisdiction. And that is why in election tribunal, the courts have been consistent. Like you have seen it in the Court of Appeal in Ebonyi. You've seen it in Court of Appeal in Benue State. And then you have seen it in the Supreme Court, because in Supreme Court case, APM brought an action for double nomination. They brought action for disqualification of Tinubu. They brought action. All of these characters of pre-election were canvassed. And the Supreme Court said, look, first of all, we lack the jurisdiction to hear a matter that is within the precincts of a political party. That you are a busybody to inquire into what happened in a political party. You see, in Jos, the person who challenged the victory of the governor did not even come from that party. He is from another political party, but pointing at the activities of the party where the governor comes from. And this is exactly what the Supreme Court said. You lack jurisdiction, you are a busybody. Then secondly, they say, even if your argument is genuine, there are two things that you fall short of. Number one, the time frame within which this action had to be determined, because pre-election matters also have a timeline. And then the forum, which should have been the Federal High Court. So they are trying to say, we would have listened to you. Would have listened to the merit of your argument. If, for example, this matter started from the Federal High Court and you're bringing it to an appeal within the time frame as provided by law. These two things you fall short of. So we lack the jurisdiction to entertain the matter. So it will be interesting to see how the Supreme Court will view the decision of the Court of Appeal. Whether the Supreme Court will stay true to its character based on the decision it delivered in the presidential, which other courts have been obedient to, or whether the Supreme Court will depart again from the principle upon which the presidential election was determined in the first place.
All right, Dr. Bala, I hear you. And I hear you say that once a case is not determined by the final court, it's not settled law. But once it is determined by a final court, it is cast on stone. Now, a lot of questions are arising from this because then it looks as if that the Supreme Court will have to determine whether the Court of Appeal is above it or it is above the Court of Appeal. And with this kind of precedent, you can now tell why there's a lot of, lack of believability in the judiciary system as, the court and the judiciary system, is viewed by the public appeal, media trial that they are going through. So tell us, doesn't this also cast aspersion on both the role of the Supreme Court versus the authority of the appeal court?
First, as a professional, when I make argument, I do not cast my argument on the basis of the character of the judges or cast aspersion on their image or character, or even to suggest that they collected bribe or anything. That is for politicians, who are not conversant with law. My argument is purely on the basis of their legal reasoning, and it is permissible within the precinct of the rule of law that you interrogate the reasoning of their lordships, right? How they arrive at that decision. Now, if there is no precedent, then you cannot question that because they sit as law, you are not a judge. But because there is a precedent, so what we are saying is that how can the Supreme Court say this is it, and this court did not abide by the decision of the Supreme Court? Because we are taught under the doctrine of judicial precedent that courts are bound by the decision of the Superior Court. If the Supreme Court said, hey, that's why I said that once the law is settled by the Supreme Court, it becomes a law that cannot be changed except the legislators in the next legislative cycle, they pass a law to change it. That law, it is binding on authorities and is also binding on courts below them. And once on that issue, it is called a settled law on the issue, it becomes the final law. And any disobedience to that attracts the anger of the court. In the days of the late Honorable Justice Nikki Toby of the blessed memory, they have been very jealous to guard the integrity of their court. That if any court below them give a decision that is contrary to a precedent they have laid, they have not failed to chastise the decision of those courts because they want stability in the legal profession, stability in their democracy. You see, because if the Supreme Court decide in a certain direction and courts below them depart from them, it will create a great deal of instability. It can destroy democracy. That's the point to put it. Because what it means is that there is no order in the judicial precedent in a country. And it is constitutional. It is not an issue of electoral act or opinion. Section 287, the judgment of the Supreme Court is binding on all courts. And Supreme Court on that issue has settled it, that pre-election matters cannot be entertained by election tribunal, either at the trial level or at the appellate level. And an example of which they said by themselves, when pre-election matters were tumbled up with the election tribunal matters and brought before them. In fact, even at the trial level, Court of Appeal at the sitting as a trial court in presidential election, they maintained that they lacked jurisdiction to entertain pre-election matters. And when it got to the Supreme Court maintained the position. So why will just be different? Just cannot be different. The decision of the Supreme Court has to be obeyed. That's what I'm saying. So it's not about casting aspersion on, I'll be the last person to cast aspersion on the integrity of their judges. In the days of President Buhari, when the judiciary was under terrific attack, I was one of the fewest persons that was up and defending the protection and independence of the judiciary. We criticized all the security and law enforcement that were conducting certain, justifiable, attack against the judiciary, because ours is to protect the institution of the judiciary. But it also includes us raising an issue that when there is a problem, it should be looked into. The retiring Justice Jatijo, when he was giving his valedictory speech, you saw how he himself highlighted the inherent problems in the judiciary. So it is important that the judiciary should set the record straight. If it is a conflicting decision based on a coordinate code of jurisdiction, then you can say the decision of my brother does not affect me. Maybe Court of Appeal deliver here, this one doesn't. But once Supreme Court has settled the matter, you have no choice. You have to follow it. And in this case, the court just did not abate their minds to the decision of the Supreme Court in PDP versus APC, that is Atiku Abubakar versus Tinubu, in Peter Obi versus Tinubu, in APM, where the Supreme Court laid the background and settled the case that pre-election matters cannot be entertained in election tribunal. And it doesn't matter, because it is a subtle thing. You can say you are making your judgment on the basis of qualification, and you will bring Section 177 of the Constitution. This same issue was argued in the Presidential Election Tribunal. When they said when it borders on qualification, it touches even the Constitution. Therefore, the court should hear. Supreme Court say, that please, one, if you are not a member of a political party that participated in the primaries or Congress, you lack the jurisdiction to challenge the matter. Two, this is not the forum to challenge it. You go to Federal High Court. And that is the settled law in the matter.
So, Dr. Bola, what will now be your expectation as this case is going to the Supreme Court?
Well, by our discipline, we don't preempt the court, right? So I cannot sit here and tell you Supreme Court must do this, Supreme Court must do that. All I'm telling you is that Supreme Court has laid the foundation which courts are to be obeyed. And if you have delivered a judgment that is different from what the Supreme Court has laid the foundation, it will be interesting for us to see how Supreme Court preserves its sanctity, how Supreme Court preserves its integrity, how Supreme Court preserves its superiority. Because it is like a case of you get a father in the house, laid an order and said this is to be obeyed. Somebody in the house did not carry out the order, and it is reported to the father. It will be interesting to see how the father either preserved his own integrity in the house, or the father, for the sake of the child, violates his own decision or principle that he has laid. Because you see, precedent matters. If you decide against the sanctity of that institution of the Supreme Court, then it has a far-reaching effect and consequence. If you preserve and protect it, then it settles all other matters that are coming, that will come, and that are going to be applied to the same Supreme Court for review. So, for example, if the Supreme Court, departs from the principle they've laid out in Nigeria now and move in the direction of Plateau, then that means a lot of other political parties have every reason to come back for the review of the judgment of the Supreme Court in respect of the matter. Because the Supreme Court can review its judgment if it arrives at that judgment, either because of misrepresentation, because of error, or whatever, or those grounds that are laid out by law. So the Supreme Court will be careful in order either to stay the honestness or to preserve its integrity. And this is all I want to say, that it will be interesting to see how the Supreme Court decide. I will not be here saying Supreme Court must do this, Supreme Court must do that. We don't preempt, the court.
All right, I know that you don't preempt the court, and I know that as a lawyer yourself, you wouldn't also want to cast aspersion. I know that, very much so. But, let's look at, calling spades here. With the level of distrust that is growing amongst the polity for the judiciary. And perhaps it may be relative on people's terms of experience or what they consider, an upright judiciary. But do you not think that there needs to be a whole overview? I mean, we are having new, CJNs and all of that coming in by next week, 11 of them. There's a new role, and in the change of guards, isn't there more to be expected from this new coming set?
I believe that this election cycle has raised a lot of issues that the Supreme Court will have to consider, especially if you look at that valedictory speech by Honorable Justice Datijo when he was retiring. He laid out a lot of fundamental issues, problems confronting the judiciary as a whole. And he talked about even the Supreme Court, how people get to be elevated to the Supreme Court without due process, either wife or girlfriend of a justice or somebody that does not qualify. And he's faulted the recruitment into the judiciary as a judge, the promotion in the judiciary up to the highest, court of the land. Now, new justices of the Supreme Court are going to come in that will enrich the Supreme Court. That will also bring about what in football, when you bring in players from substitution, it will say that you're putting in life into the blood of the system. And then you will see that excitement in the football. You see change of strategy. You see them move it. Now, even though in Supreme Court, strategy or principle of law is constant, but how they look at it will be enriched by the robust, intellectuals that are going to be added to the Supreme Court. In other jurisdictions, like maybe the United States or United Kingdom, usually judges are known by their specific character. So a judge might be known as, this is a criminal justice. That is a judge, when it comes to criminal matters, just give it to him. Or this is a probate justice. Or this is a justice that deals with conflict of law. Or this is a justice, his own is he looks at because in most jurisdictions, they don't have election petition. The electoral system is so clean that people hardly have the energy to come and do petition. It's only in Nigeria, even in Africa. Look at Malawi and Kenya. They conduct free and fair election. Liberia just did election, and they did handover. It's only in Nigeria that INEC is a member of the executive. Can you imagine? And you look at all the decisions across various tribunals in Nigeria. Tribunal will say, well, INEC made the mistake, and we are on to decide based on the law. And INEC will go unpunished. Even the Supreme Court faulted INEC and talked about the confidence that it will be weighing down in the public without punishment on INEC. So INEC now.
All right, I think that probably we have some interruption there by the network, but just, to go ahead to buttress this point.